An appearance. Hi, I'm Darren Findling of the Probate Pro, and I'm going to be appearing today to explain a SCAO form MC02. SCAO for State Court Administrative Office, MC02 is the form number. These forms are widely available. You can get them for free through my office. Visit theprobatepro.com, probate-court-forms. There's a link on my YouTube channel for those forms, which are free. Let's examine the use of this particular form. Like all of the SCAO forms, they are guided by particular statutes and court rules. In this particular case, you can see at the bottom right corner, there is a series of court rules, MCR 2.117, MCR 3.915, subsection C, and MCR 3.916, subsection B. These court rules give rise to this particular court form. 2.117 is the general court rule that speaks about appearing on behalf of a client. So an attorney appearing on behalf of a client in a cause of action. Now think of it like this. If the client, plaintiff, or defendant is involved in an action, and then an attorney is going to join in and represent that person, 2.117 guides that process. The idea is that they're going to come in and appear on behalf of them. It's kind of a weird name. I think of an appearance like Paris Hilton appearing at a nightclub, but it really is identifying that you have been retained or court appointed and you are now the attorney for the party in that cause of action. It could be a plaintiff in a cause of action, a defendant in a cause of action. It could be in a deceased or guardianship or conservatorship estate proceeding, any of these types of matters. When the attorney is coming into the file, that's called an appearance. Now to come off the file, then you would withdraw as attorney from the particular file. Now Michigan also has appearances that can be limited in nature and scope. There's a particular court rule that defines that an attorney can come in, for example, for one court hearing or a particular specified manner that has to be identified within the representation agreement. But generally, appearances are occurring until such time as the attorney has withdrawn from that particular court matter. The other court rules relate to the appearance as a guardian ad litem, and so we're going to really focus on 2.117, the use of this form. In the top left corner is the county in which the matter is proceeding. As you can see, it says State of Michigan, Judicial District, Circuit, or Probate. This form is versatile, can be used in any of those three court systems. Top right corner is the case number, and then in the big rectangle, it's an appearance. At the beginning, it's pretty obvious here. These are pretty intuitive areas to fill out. It talks about the court address, the plaintiff's information, the defendant's information. And then, of course, if it's a probate or juvenile proceeding, it says in the matter of. That's the name of the person upon which the proceeding is occurring. So, for example, the estate of John Doe would be in the matter of John Doe, and you check the little probate box. As we work further down that document, it provides that to the clerk of the court, the register of the particular juvenile or probate court, and all attorneys of record and unrepresented parties would be specified there. So the idea is that there's a court rule here that identifies who are the interested parties within a cause of action. Now, in a civil case, it's the plaintiff and defendant generally. It's pretty obvious. But in a probate proceeding, for example, or a guardianship proceeding, there are court rules, MCR 5.125, that define who are the interested persons who have to be given notice of particular proceedings or filings within that case. So you're going to identify those people there and list both the people that are represented by counsel as well as the unrepresented parties. So it's really important that you complete this section carefully, understanding the statutes and court rules that apply. And again, with all of these SCAO forms, we strongly recommend that you work with a skilled, competent probate lawyer, if of course it's in the probate context. The next section says, I appear on behalf of. So the idea is the I is the attorney that is completing this particular form, and you're going to identify the party or parties that you're appearing on behalf of, and then are you the attorney or the guardian ad litem? And then it says, and request copies of all papers. The idea being that once you have filed your appearance, you're entitled to notice of all the paperwork that has been filed. Now again, it identifies, have you been court appointed or have you been retained by? And the idea here is if you get this document and you're looking at it, retained by means you're hired. The person hired you to be their lawyer, generally being compensated, but they're hired. Court appointed means that under the court rules or statute, there may be a basis for the attorney to be appointed. An example of this would be in a guardianship proceeding. So for example, in a guardianship proceeding, if the individual that is being sought guardianship over objects to the appointment of a guardian, there's an automatic right to a court-appointed attorney, and that attorney would appear through this particular appearance process. As we work our way further down the document, it says I certify that I represent no other interest whatsoever of any party up to this cause except as follows. So the idea here is this is a conflict of interest statement. The idea is that if there is an ethical problem with the representation, you would be certifying it here, and then there may be some exceptions to the rule. So for example, there could be a dual representation or a conflict, but it may be a permissible conflict, a conflict that can be overcome through particular rules. So that's the section that you'd identify there, and then of course the signature of the attorney. Now again, I'm not doing this particular form and explanation for lawyers out there. Lawyers know how to complete this. This is really an explanation for people that may receive an appearance in the mail and not really understand what this particular form means and how to use it. Most importantly, if you receive an appearance in a matter upon which you're proceeding, that lawyer is now entitled to notice as if you were serving the individual before the appearance had been filed. At the Probate Pro, we are passionate about everything probate. If you have questions about the appearance or any probate-related issue, visit us at theprobatepro.com or call us at 1-833-PROBATE.